Hi there, I'm Sam Carter, Managing Director of Specialist ADR Sets, Int-Arb, Arbitrators and Mediators. This is the last of our current webinar series, which covers the insurance industry. To continue our pattern of previous webinars and to set the scene, the COVID-19 crisis has led to policyholders reviewing the nature and extent of insurance cover that they have available, which might respond to damage that they have suffered. Cover will turn on specific terms of the relevant policy and underlying facts. Insurers have come under both media and political pressure to respond quickly to these claims, but as the Chairman of Lloyd's of London is reported to have said in the Financial Times, the insurance industry could be in jeopardy if it was forced to pay out the COVID claims that they've never intended to cover. So the key types of insurance cover that are affected are as follows: business interruption insurance, employer's liability cover, contingency and events cancellation cover, cyber risks, D&O, trade finance, trade credit cover, and reinsurance. We have a distinguished panel today, including two guest speakers. Our first guest speaker is Richard Wise. Richard is partner in the International Dollars Litigation Group that specialises in insurance and international commercial arbitration. His insurance practices focus on the representation of major national and multinational policyholders. His experience includes a full range of business insurance. Our next guest speaker is Steve Clark. Steve is practicing mediator and insurance industry professional. Steve began his career at Alexander Howden & Swan, now Aon, and subsequently held senior broker positions within the insurance industry until he became executive director in charge of international reinsurance claims at Willis. He moved on to head the reinsurance team of Lloyd's Claims Office and then went on to several Lloyd's managing agencies. Finally, Jane Player. Jane is a member of Int-Arb and leading international mediator. Jane was formerly a partner at King Spalding, before then co-head of International Dispute Group and head of disputes at Bird & Bird and DLA, respectively. The focus lies in commercial and contractual claims, including insurance, construction and fraud, as well as project disputes within a wide variety of sectors. Moderating our session is Wolfgang Kumberg. Wolf is also a member of Int-Arb, mediator and arbitrator. He has over 30 years of experience in international business, having assistant general counsel to Northrop, and before that, Lytton Industries. Wolf has experience across a wide variety of sectors, including aviation, insurance and reinsurance, investor state and commercial disputes. Wolf, over to you.
Well, thank you very much, Sam. And as Sam said, this is the last in our series, but perhaps the most topical at the moment, and that is because insurance is going to play a big role in the COVID-19 recovery, whether it be, and we're yet to see whether that's because policies will pay out, but in particular, also looking forward to how insurance is going to be written after COVID-19. So I think to kick it off, the Financial Conduct Authority, the FCA, said it would seek clarity from the courts on whether the wording of some of the insurance policies should provide cover during the pandemic. It has selected 17 examples from business interruption insurance policies that it's going to ask the court to review. And these are policies used by 16 insurers. So 8 of them have been asked to take part in the court case. And just quoting from the FCA, they said that we expect the test case to provide guidance for the interpretation of many other business insurance policies that are not in the representative sample. So just leading off and maybe asking Richard first for his comments, even if the ruling were to favor policyholder, claimants will still face hurdles and lengthy discussions over how much they are owed. That means any potential payments are likely to be months away. The FCA is effectively resolving ambiguity over some of the wording on some contracts. So my question to you, Richard, is will the FCA case actually help to clarify business interruption cover generally, or only the specific policies under review in the case?
So the decision, when we get to a final decision, will be binding on the insurers who participated in respect of the wordings that are in issue. But then there's obviously the broader question of what that means for everybody else. I mean, in my view, it would be impossible to capture every wording and every possible argument that's out there. But actually, the FCA's legal team have cast the net pretty widely in choosing their wordings and their samples. And based on what we've seen with our clients and the wordings we've looked at, I think that there will be guidance, if not definitive positions, for many policies, because a lot of the issues are broadly similar. The wordings have nuances, and those nuances can be important, but you know, they're of a type that means that there should be a conversation to be had. Of course, when we get to a final decision is a slightly different question, because I would imagine that whichever way this expedited hearing that's going to be heard in July is found, there will be an appeal, and it's already been contemplated that that might be a leapfrog appeal to the Supreme Court for later in the year. In terms of how it is that these claims might be resolved and clarified, I think it is right to say that there are still going to be issues on specific claims anyway, because depending on the factual circumstances, there's going to be questions raised about how causation arguments work for different policyholders. And actually, you're still going to have to go through a loss adjustment process of some sort as well, even if it ends up being abbreviated and done for categories. And with that in mind, one of the kind of topical issues that people have talked about a lot is trends and variations clauses in policies, and particularly a challenge to the Orient Express decision, which a lot of insurers have pointed to here to say that even if there was cover, there'd be no value in it. Actually, even if a trends and variations clause doesn't work in the way that Orient Express says it does, it's still going to need to be applied to the factual circumstances. And then probably the last thing to note is actually, because we're dealing with insurance claims made under extensions to a lot of policies rather than the main body of cover, in a lot of instances, not every case, but a lot of instances, the limits will be below the threshold for referral to the Financial Ombudsman Service of 350,000. And that might influence the approach that people take when they are considering how to react following the guidance from this decision.
Right. Well, thank you, Richard. Sam had outlined perhaps some of the other types of insurance cover that could be affected by COVID-19 and perhaps therefore also bring about claims. So given the FCA test case only deals with business interruption related policies, what happens to other COVID-19 impacted coverage such as D&O, which is another type of insurance that might very well be claimed against due to COVID-19?
Yes, I mean, you're absolutely right. The test case is very much BI focused, so there isn't any direct read across, but it is having a wider impact. I think the market, it's fair to say, different views on it, but was already starting to harden. Certainly the first time in my career that's been the case, and this issue has really exacerbated that. So I think there will be a narrowing of the cover that's available. I think we will start to see exclusions introduced. So you highlighted D&O. We've already seen exclusions coming in to do with particular insolvency issues, and that will be of concern for directors in certain sectors that have been hit really hard here. And you know, there's been a much longer process for the underwriting of the risk to try and get those exclusions removed in many cases. There's also down the line likely to be disputes on the meaning of exclusions of that type that are introduced. And in the same way as arbitration and mediation has been used by insurers over the years to avoid precedents being set and to have things dealt with confidentially, it may well be the case that that's the approach taken to these new wordings as we start to see them pushed. And then, of course, there is, and this is something Steve might have a view on, I think there's probably likely to be an increase in the cost of cover as well for particular to maintain cover that people currently have.
Right. Okay. Thank you, Richard. Perhaps one other question which could become relevant, and that's more looking at the insurance broker's side of it. Do you potentially see that there could be claims against brokers for not having advised on appropriate insurance cover to deal with pandemic risk?
Yeah, there have been a few comments about this in the press, and I think it's understandable that there's going to be some scrutiny. Broker negligence claims are very fact-specific, so a lot is going to turn on what was actually done between the client and the broker in the specific instance. So what instructions were given, what was the nature of the business being insured. And like any negligence case, you'll need to go through duty, breach, and causation. So just thinking about those, from a duty perspective, yes, the broker will have a duty of care, but actually when it comes to ascertaining the client's needs and considering the information provided to it, you'll have to look quite carefully at the interactions, and the case law about brokers' duties to advise on scope and type of cover is quite mixed. Breach, again, the factual circumstances will dictate a lot. Causation's where it could get very, very interesting if these claims are brought, because actually you'll have to ask yourself the question, well, would the client have bought the insurance if it had been, as it says, properly advised? And of course, there's then going to be a question about what was available in the market and what the cost of it was. And timing becomes really interesting there, because you can see a scenario where a policy that was renewed last summer may have a very different set of circumstances to a policy renewed in the new year. So right. I think there will be questions raised, but there'll be interesting claims.
Yeah. Okay. Well, that's an interesting thing to follow as well, Richard. Well, thank you very much. Perhaps just turning to you now, Steve, and with your own background in the industry. Bruce Hepburn of McTavish warns customers will take far more care when buying insurance. So going back to Richard's point now, businesses will scrutinize their policies as they never have before. And he said, I think the industry is heading towards a much bigger problem than they have now. So just in that context, Steve, I mean, how do you see insurers' policy changes on renewal? Will pandemics be excluded? Will cover be available at additional cost? What's your view on that?
Yeah, thanks, Wolf. I mean, obviously, it's the $1 million question, isn't it? Or probably $1 billion question or more. As Richard says, the natural reaction for the market would be to say that exclude more, to maintain the price or to keep the price in control, based on what we know now, exclude more. And then, of course, you've got to get the wording of that correct, because if you don't get that, that's then going to be challenged. Oh, well, I didn't think I'd excluded everything. I only excluded that side of it. I mean, one rhetorical question I would have for us is, if we ran businesses, I mean, taking somebody who owned a series of greeting cards shops, and you were renewing your policy this time last year, would you have looked at what it said about pandemic? And if you did, probably you'd ask the insurer that, they may have struggled to go into much detail, because it was so far from, those of us who have been around a long time, this is such an unusual circumstance to see the whole nation closed down. I don't think any of us could have predicted it at all. So I think we have to be a little bit cautious, or a little bit, have to recognise there's a difference between what happened previously and what will now have to happen. And finally on that point, I think insurers would encourage businesses to apply more scrutiny to purchasing their policies, because I think on that basis, and ask more questions and ask for clarity and have a better understanding. But inevitably, nobody, if anybody is able to predict exactly what sort of full cover is needed for a policyholder, then they're going to be some sort of sage, aren't they? I mean, nobody knows what's going to happen, and all policies develop based on previous circumstances year on year on year.
Right, yeah. Maybe just looking more practically at the current situation, and maybe let's just take BI for a moment, because there is the test case that is going through right now. At the moment, if you were a policy holder and you were looking to try to negotiate with respect to your own particular claim, do you think insurers are going to be reluctant on that BI cover in particular at the moment to try to agree settlements without waiting for that case to be heard?
I would think they would be reluctant, probably largely based on the timing as we understand it. We think there's going to be a judgment, pretty much imminently, in which case it would make sense probably for insurers to wait. I mean, if we were talking about a 2-year case, then that would be different circumstances. But the thing with insurers, it's all about certainty, it's all about precedent. And if they're looking at coverage, and there's any sort of coverage issue, and there's a whole series of previous, decisions, legal decisions that support one argument or the other, insurers would feel comfortable about how they pursued any negotiation. Things are so much up in the air at the moment. I think that some may take it as an opportunity But without wanting to be too cynical, I think insurers who go on that basis will be looking for substantial discounts on any claim to get it, I won't say, I'll say nuisance value. I think more than nuisance value, but certainly looking for a significant discount if you want a decision want us to make a decision on your claim before there's a judgment.
Right. How about coverage outside of BI, looking at some of the other types of coverage that might now be subject to a claim? How do you think insurers will be dealing with that? For example, D&O cover, which isn't affected by this test case.
Yeah, they'll probably be even more confused about that than they are about the BI cases, because at least the BI cases they can look at and they can make some sort of, they will all be making judgments themselves of what they think will happen or should happen, albeit that may prove not to be the case, as we know. I honestly, I just think that it is. I think the BI will be an area that will be dealt with first. I'm only guessing this, but I'm guessing it is financially it's the most significant area, and therefore, has an urgency attached to that. And then, there'll be people in the other. I don't know for certain, but I would imagine that people in the D&O areas are sitting back for the next few weeks and looking to see what happens in BI and say, okay, we'll deal with this once we have a better idea of what's happened there.
And just on that, Steve, I think one of the interesting things might be the US is ahead of the UK on this, as it always is, but securities actions being filed in the US, scrutiny on management, those claims naturally will take a while to come through. And whilst there will be some issues at the moment that are very relevant to D&O for the businesses affected, there will be a whole load of claims that actually are months away, and it's only then we'll really see what happens.
Yeah.
Right. Well, Steve, just from your own perspective and what you might have done when you were in that seat, I mean, would insurers be looking at potential pragmatic settlements and in particular utilizing mediation to try to get to a resolution? I know there was AXA, for example, had just said recently that they prefer their policyholders to try to negotiate rather than to bring claims.
Well, I think the first thing that insurers should be doing, which they haven't always been so good at, is to actually, to use that American expression, reaching out to their policyholders. So at least communicating with them, keeping them informed of what's happening, explaining if they're not coming to any sort of determined, clear, determined decision, explaining why that they're not in a position to do that at the moment. And all us mediators would say, wouldn't we, that one of the first things to do is keep talking. Let people know what's happening. They may not like it, but at least they do know, they're up to date. They feel they've been involved, and at that stage, as I say, I think what I would be saying is let's see what the FCA case judgment is, and I probably would be telling people we were doing that, and then. Okay, as a result of that, let's sit down with policyholders and their representatives and talk about what we do next, and that will depend on negotiating. As we know, every claim has a value of some sort. There's nothing, you never get away with zero for a claim. So something will be paid, but it's a matter of where on that scale, up or down, it is. And the best way of achieving that is obviously to talk to the policyholders, particularly as in many cases, it will be a long-term relationship, and I'm guessing insurers won't want to lose those policyholders, and that includes obviously not losing them because they're no longer in business and therefore no longer need a policy. So I would hope insurers would be taking a responsible attitude, but picked up with the point from the chairman of Lloyd's that if insurers pay every single claim to its full value, then everybody's going to make everywhere. There won't be an insurance industry probably, so because they're only businesses and equally have financial pressure.
Yeah, I mean, mediation, of course, provides a confidential platform for these discussions to take place within. I mean, does that work within the insurance industry? If something is confidentially settled, do others learn about it?
Well, I think if you had a case, if you had isolated one policy for, and let's assume that would be for a very large organisation, so a major policyholder, and you've isolated that case and you took that to mediation now with so much focus on it, it will be very difficult for someone not to get a good, who's smiling most when they walk out of the mediation almost, someone's going to get an idea about what happened. I think if you talk to the point of saying, okay, we're now going to talk to all our policyholders and work through mediations with them, then I think mediation confidentiality works well. But you have to recognise it's like any walk of life, wherever the focus is, if there's a lot of focus on one thing, that, particularly in the world of social media where there will be, disgruntled policyholders or whatever it might be, or other people. I mean, clearly there'll be, if organisation A are mediating, the equivalent organisations will presumably be looking at it thinking, well, why aren't we, or when can we, or what's going to happen? So, but I think in general, confidentiality will work well because, there is no need for it to get any further.
Right. I mean, Richard, what do you think from your perspective, if you were representing a policyholder here, would you be looking perhaps to try to mediate before you commenced an action?
Yeah, I would. I mean, I think I'm always mindful as well in this situation that, an insurer is going to need to carry its reinsurers with it. And therefore, when you're looking at it from the policyholder perspective, you need to think about showing the insurer it has a liability and its ability to pass that liability on. So, that's going to be a factor in any settlement discussion that you have. But yes, in the work we do, mediation is always a step that we're looking to take. We've got mediations in the diary now on claims. Here it is made slightly trickier by the timings because I do think there will be a reluctance to engage until we at least have a first instance decision. And one of the, probably the wrong phrase to use, but one of the bits in our armory that we might use to get insurers around the table would be to say, you're exposed in relation to an unreasonable delay in payment, and therefore we can claim additional damages from you, and our businesses, our clients are suffering. Actually, the very fact of the FCA intervening might make that a harder argument and might make insurers feel more confident in saying, no, we wait. So there's a lot of dynamics at play. I would expect that post-decision, there might be a little bit more appetite.
Right. And just picking up on Richard's point about reinsurance, I mean, clearly that's a whole other subject, and, causation there is going to be fascinating. Aggregation is going to be a fascinating topic. Which I'm sure will keep the legal industry very busy for the next few years. And I think, I mean, clearly reinsurers would be saying, well, act as if I'm reinsured, but they'll be busy checking their policies as well and making sure, having their interpretations. I haven't seen any quotes from any of the big, major reinsurers about this at all. I mean, perhaps I've not been close enough in touch, but they will certainly be eyeing this very closely.
Right. And maybe finally, Steve, and you've already alluded to this already, and that's the public pressure, and I've even seen some threats of potentially legislation, particularly here in the US, if insurers are taking a very difficult position in denying. And then I guess just the CSR, the corporate social responsibility side of it. Do you think that will drive insurers to a certain extent, just their public image?
Well, I would hope that would be driving them on a daily basis on everything they look at, because, the days when insurers would just back away, say no, and then back away and let everything else carry on, hopefully are long behind us, or certainly pretty much so. And yes, there's a whole dynamic around the fact that the insurers do need business. Much as this is going to be a painful time financially for them, they need next year's policies and the year after and the year after. There's the added fact that most of us, I think, believe there's going to be a second spike and lockdown in some shape or form. The closing of bars and restaurants later this year wouldn't be at all a surprise. Imagine closing them through the Christmas period when most of them probably make half their income, and the potential BI losses there. So if you were renewing a policy in the next month or so, what are you going to be saying about that? And all those issues, plus the public pressure of insurers don't want to be the bad guys.
Right. Well, thank you, Steve. Jane, perhaps turning to you now and more with the mediators hat on here. As I had already mentioned, AXA has called on dissatisfied customers to negotiate rather than litigate. And we've talked a little bit about the use of mediation already, but as a mediator, do you see mediation or maybe assisted negotiation as being a possible avenue for resolving these coverage issues?
Yes, thanks, Wolf. I really do. And I don't want to call it mediation because I do think it will be pre-dispute. It will be around difficult conversations that need to be had, particularly on big policy potential payouts. And I really do see mediation being a very, very useful tool for both sides. It's interesting, Steve mentioning about renewals. You know, if you are a retail business and you are facing Christmas, do you or don't you bring in Christmas stock? If you've got a potential BI claim now, isn't it better to sit down with your insurers because you're offering to renew or you want to renew with them and maybe do a deal based on what your current policy says with a view to being able to at least agree what you're going to get covered for by Christmas? So you've got a little bit of give and take there on a renewal and a conversation that you can have with the insurance companies. My other comment is that these are just by listening to Richard and Steve talk, these are complicated issues. You know, you've got certainly an insurance policy, you've often got reinsurance, you've definitely got a broker who's trembling in the sidelines, wondering whether he might get a hit if the insurance company doesn't pay out, as to whether he did or didn't place the right kind of insurance as he was asked to do. And then you may also have the insurers saying to the policyholders, you have a claim elsewhere which you must pursue first before you can come knocking on our doors for your insurance policy. So act as a reasonable uninsured and go get them. And indeed, some insurers are, as we all know, happy to fund that litigation in the hope that that's where you'll get your payout and the insurance policy won't need to bite. So that's a very complicated set of circumstances, and one that actually, if you could get everybody around the table to resolve something, exactly as other speakers have said today, you might then have a business that will survive. You might have an interim payment that will be just what they need during these difficult times, and you might have a company that will look to you again for insurance. And we see this in lots of home policies where you'll have adverts where the insurance companies say, we always pay out 96% of all our claims. And that becomes a marketing tool for them. Embarrassing, isn't it, if they then clamp down and become the old-fashioned closed shop, all of them follow the market trend and stay stum. For some insurance policies, for some of the more innovative players in the market who are maybe the newbies, this could be a real marketing opportunity for them to be seen to be actually approaching, having the conversations, having open, transparent negotiations in a mediation where it's safe, where it's confidential. And I take Steve's point that these things can get out, but if you're all determined for it not to, then bar saying there has been a mediation, which will just simply encourage others to at least ask for mediation, you may get yourself a deal that actually is exactly as we talk about, the win-win that helps the insurer keep its reputation as being a good person to place your insurance with, and an insured that carries on to fight another day. So I think mediation is not only an incredibly useful tool if it's seen as facilitated engagement and not a mediation looking to solve everything all at once. And I think it also could be something that enables people to think opportunity, not risk. Insurance is all about risk, but this is all about mitigating your risk by putting in a suggestion of a deal now, which is better than 2 years worth of fighting in the public arena, where the downside, frankly, for an insurance company is huge because of the precedent it sets.
Right. And I think the environment itself with respect to conflict and how conflict is to be resolved is really changing in the face of COVID. We've had the Cabinet Office give guidance on the 7th of May, which has asked business to act responsibly when looking at these types of disputes. Do you see that, Jane? Do you see that people are taking a more pragmatic view and trying to resolve these issues earlier than they might have previously?
Yes, absolutely. And people tactically using that 7th of May guidance from the government to encourage people to come to a negotiation earlier. That combined with the comments made by Lord Phillips and Lord Newberger in telling us that the courts are absolutely inundated now and won't be able to cope post-COVID return from COVID, has really encouraged people, I think, to come to the negotiating table. But of course, it works both ways. I mean, acting fairly and reasonably in a COVID time is for both insured and insurers. And if you look at paragraph 15 of that guidance, there's a whole list of things that it's expecting you to do. Now, in no way is it asking you to ignore contractual obligations. We all, as lawyers, both retired lawyers and existing lawyers, will know that the contract is king. But if you could negotiate as an insured, in saying to your insurer, if I were to pursue this particular claim, my claim would be X if I were to win. But if I could do a negotiation with you now, I'd accept Y, because I appreciate that insurance companies are nevertheless not completely bottomless pits. Everybody has to be reasonable in the way that they negotiate. There's every chance that actually, if people follow this government guidance, that there will be negotiations when perhaps before people would have rushed to their lawyers, polarized the position by pleading it at its extreme, and just sat and waited to see what a judge would say in due course. That actually might end up being a failure for both parties.
Can I just come in there? Well, sorry, just to add, I think it's a very good point, the last one particularly, about the chances of there being definitive answers on this, across a range of different policies, I would imagine is almost impossible. And with some idea, some guidance of where the courts may be thinking from the FCA case, I think that gives every opportunity for insurers to say, okay, we've got a bit of an idea now. We think we're probably on a bit of a losing wicket here, and therefore we'll sit down and negotiate. And if we get 20% off every claim by paying it quickly and causing the minimum amount of fuss and saving the policyholder management time, etc., then we've got a good deal as insurers, and we could manage that. And of course, the other group of people we haven't even mentioned are actuaries, who will no doubt be projecting away furiously as best they can. And the more information that they get, and the more certainty that they get, clearly gives them a much more comfortable position to base what's going to happen in the future. But
yeah, and we see this, don't we? I mean, we've seen insurance companies in the way they deal with med and ed claims, the way they deal with accident claims. They're very pragmatic in the way that they're prepared to look at it when they've got volume claims coming in. So I think that's an opportunity for clever insurance companies who want to maintain reputation to actually almost set up a scheme and say, look, we would actively like to encourage you to come to mediation. We will pay for the mediation. It's such a small cost.
Yeah.
Come and have a conversation with us, and within certain criteria, because we've all been down the route as lawyers in interpretation claims where clauses are not quite the same as the precedent we're trying to rely on. You're just hoping to goodness the judge follows your logic, that it would make sense. We've all of us done claims in relation to indirect loss in contract claims, and is that particular claim, that damage foreseeable and within the direct loss that you've got covered between contract and contractor? It's exactly the same in insurance cases. It's quite a brave man who believes he's got a surefire case against the insurer, or as an insurer as a defence, unless he's got an absolutely, as Richard said, a clause that's identical to one that's already been decided on by a judge. And we all know that judges change their mind. So why would you risk the costs, even if you've got a pretty cast iron case? The nuisance value and the throwaway costs that you won't recover always indicate to you that you should give it a go at a mediation, because if nothing else, you hear early the arguments being put by the other side as to why they think they're more likely to succeed than you are. So I think it would be business bad sense not to use mediation as one of your tools. And on the basis it's not an alternative to litigation, it's something that you can use at any stage during the litigation, or indeed before the litigation, to try to get an idea of whether that particular insurer or insured or broker is willing to be pragmatic and sensible for the greater good and for the continuing of the relationship.
Just quickly, sorry, Wolf, and I mean, again, this is a bit sweeping generalisation, but I think it holds up fairly well. insurers never want to go to court because they go in front of a judge, and what seemed a very good argument back in their office 9 months ago when they were debating it, when it's being put to a judge and their QC and the other side's QC are furiously arguing the different points, it doesn't sound quite as good and they're at risk. And I think generally when they do end up in court, and again, this is very much a generalization, but is where proceedings have been started against them to recover the claim, they have not responded as quickly or as clearly and as communicatively as they could have done. And it's been two sides battling against each other. And actually, if they, before proceedings are issued, say, right, there's an issue here, there's no clear answer one way or the other, let's sit down around the table and talk about it, let's mediate. The mediation would probably be several mediations, I think. It would be, because there will probably be some fact-finding needed in that as well, if you go early. But there's nothing wrong with that, if that's a good way, it's a good way of doing it. And on that basis, I think there's a good, I think mediation will play a really valuable role and avoid, and then, okay, if you get to a point where it's at loggerheads and they've got a policy, and I'm going to say this as an insurer, aren't I? But generally, those cases are the ones where the policyholder is being completely inflexible and probably not terribly realistic about things because they're not listening to all the arguments, and whether that with legal representation or whatever. So mediation, get in early.
Just picking up on that. I'm sorry, Steve. I was going to say, picking up on that. I think one of the things in this case, all claims of any type are more or less personal. And many insurance claims are business to business, and the personal element doesn't come in. Here, there is a lot of strong feeling. You can see that in the press coverage. You can hear it when you talk to policyholders. There's a personal element to it, and actually, mediation is an avenue for that personal element to be explored as well, and to try and take some of the heat out of it by having conversations. What has gone down particularly badly has been the blanket nature of some of the refusals and the non-engagement. And it is an avenue that might temper some of that.
Yeah. By personal, you mean emotional, don't you? Yeah.
Sorry, I do. Yeah.
So true. If it's your, if it's your family business, it's going down the drain because people are not helping you. And some of these poor businesses have been through all the storms and all the natural disasters we've had this winter, and have only just got them back on their feet, only to find COVID's closed them down yet again. So you can really understand there will be some really fiercely felt emotions here that need to be dealt with. And I'm afraid litigation or arbitration is not an easy place to vent those emotions or for them to be taken into account, whereas in a mediation, at least they can be heard.
An insurer that says, we understand you've had a really tough time and we want to try to help you come to resolution.
Yeah. Already you've got them on your side. Yeah.
It goes a long way.
Yeah, agreed.
Yeah.
Jane, just perhaps to finish off, and at the moment, of course, there's still not the ability to meet face to face, or people will be extremely reluctant to do so, even if that is now possible. Mediating virtually is probably still the best way forward. What do you think about mediating virtually? Does that provide the same benefits as mediating face-to-face?
It's a great question. And I think if you'd asked me this 3 months ago when we were all quickly trying to learn how every online platform worked, you might hear me being a little bit more nervous. But 3 or 4 months in, we've all been at it now for quite a while, and it's amazing how effective it is. It needs more preparation. It needs probably a practice session to get both lawyers and their clients comfortable with the environment. But it is extremely effective. It will never take the place of in-life mediations, because it's got a real value to that. But there are some advantages over in-person mediations. International disputes can be dealt with very quickly online. There's no travel, there's no management time wasted in terms of getting to places. And my experience has been that often people who do want to express perhaps a degree of emotion around what has happened to their business find it easier on a screen than they would do across a table. And it's sometimes the others find it easier to take, and they can take a moment if they need to. So actually, before people dismiss it as being not effective, I think they should give it a go. Most mediators will do practice sessions with people to get them comfortable. I think so far as lawyers are concerned, there was some reluctance at the beginning. I think most people were just paralyzed by COVID and didn't know quite what to do with their disputes or things brewing. But now people are realizing they're going to have to get on with it. We could be here for another year like this. And so they are putting their toe in and trying remote platforms like the IAC platform, which is excellent, and others, and are getting good experiences. And that's helping things. And I think lawyers are a little worried because in a real life mediation, you're sitting next to your client, you are holding their hand and you're leading them through negotiations, either information giving to the mediator in private session or exchanging how you're feeling in a plenary when you're all together. Much more difficult to do that if you're on screen. You can't give your client a gentle kick under the table virtually. So preparation again is everything. You need to sit down and work out what might be said to you, how you might react, who should do the opening. We always like to encourage principals to speak, but how should that happen and in what way? Should you have the text and the emails open between you so that you can say, I wouldn't go down that road yet or whatever. But that just means that we prepare better. And frankly, preparing has changed dramatically in mediations generally now that we're doing it online. People are not giving me papers the day before and then just turning up and hoping for the best that we mediators can perform our magic and get rid of their problem for them. We're actually engaging much earlier with people, practicing, thinking through what might be said. Are there other documents that haven't been exchanged that could be useful? Is there someone else who needs to be available to us? So an upside to online mediation has been much better preparation, people coming in with right attitude. And the last thing I'd mention about the advantage of online mediation is if you can encourage the parties to have a practice session and together. So what I tend to say to all of them is, let's have just a practice session on the procedure. We're not going to mention the facts. We're not going to discuss the case. We're simply going to get together for 15, 20 minutes, and I'm going to show you what it feels like to get put in a breakout room, to give you comfort, to know that there's nobody else listening, and you can test that out. So you've got the comfort to know when you're in that particular breakout room, it's just you and your lawyer speaking, and me if I get permission to come in. But the other fact is it gets them used to seeing the other side on screen. And that is a huge piece of psychological preparation, which is really, really helpful to enable the mediation to get going straight away. And that leads to the fact that my experience has been online mediations tend to take less time. People want to get on with it. They know what they're there to do, and they've prepared so well that they are the dynamic of the day that we talk about as mediators for mediations to work even more applies in an online situation. You've got to factor in time out. I mean, 9 hours looking at a screen's hard work. So you've got to say to people, let's be sensible. We'll take a 15-minute break. You can go walk around your garden. You can come back. You can have a lunch break like we always would. You can just be wandering into your kitchen and helping yourself to a sandwich as opposed to having the wonderful IAC catering coming into you. But you are getting food. You're getting energy back so that in the afternoon we can carry on. So you've got to think it through in a different way, but it's very effective. And I hope people don't just leave disputes to stagnate or think that positional negotiation, which powerful though it is and how great our clients are at it, it's very different from having a third party facilitated discussion where they're listening out to the real needs and wants of each side and guiding the others to make proposals that you know are going to work because you know they're going to be palatable. That is the key, which makes mediation work, as we all know, as opposed to negotiation, which can try and sometimes just go nowhere.
Yeah, thank you, Jane. Maybe, Richard, you could just say a few words on that, representing clients. Are you reluctant to go to a virtual mediation?
So I think speaking kind of across the firm, we've had some good experiences of virtual mediation so far. We've had some bad experiences. That's probably the same as all mediation, actually. I do still think, with my lawyer's hat on, that there's a horses for courses element to it, and that some disputes will be more suitable than others. But I do think we will all get more comfortable with it, and I do think that from an international perspective, it will make things a lot easier to pull parties in and to facilitate having discussions, and to avoid it necessarily having to be something that, yes, you've got to prepare properly, has to be, 6 months, 12 months down the line.
All right. Well, with that, thank you. And Sam, I'll turn it over to you.
Stuff. Thank you for everyone for joining. And just to touch upon, I completely agree with what Jane said. You know, this is a new normal. I think mediation has found a home online, and I think everyone was slightly sceptical at first about doing disputes online. But I think as we're moving forward and the platforms available, people are getting more confident in running these disputes. And with an INAC hat on, we try and make the experience as real as possible. With physically separated breakout rooms, and I think the experience as well. I mean, without worrying about if anyone's going to drop out, if there's going to be technical problems, there's always someone there to sort of ensure that the dispute's running, so that everyone can concentrate on the dispute at hand. So, but just thought I'd add those comments. But yeah, thank you everyone for joining and participating. I thought it was a really insightful discussion, and we'll watch your space.